evening, everyone. Welcome to the Council Exchange e-meet on AI patents and power. Who wants innovation in the age of generative tech? Brought to you by LexTalk World Conference Exhibitions, APAC ME. So AI is no longer just supporting innovation; it is creating it. This shift is raising critical questions around ownership, inventorship, and regulation across jurisdictions. Today's 60-minute session brings together leading legal experts to decode these challenges and what they mean for businesses and legal leaders. A warm welcome to our esteemed speakers and all participants joining us today. I am Karthik Gaur, Manager Client Acquisition and Operations with LexTalk World, and I will be your host for today's session. We are honored to have with us Ms. Deepalakshmi Vadivelan, General Counsel and SVP Legal Global DPO, Quess Corp Limited. Next, we have Mr. Saurabh Anand, Lead Counsel, Akamai Technologies. Then we have Ms. Sushma Shankar, Vice President Legal, Accenture. Then we have Dr. Akshay Kanch Chaturvedi, Corporate Head, IPR, Gujarat Fluorochemicals Limited. Then we have Mr. Krishna Chellavilla, Head Patents, Prosecution and Copyrights, Tata Consultancy Services. Lastly, we have Mr. Sergey Medvedev, Partner Gorodiskin Partners. Now, to lead this discussion, I now hand over to our moderator, Mr. Saurabh Anand, to steer an engaging and insightful session. Over to you, Mr. Saurabh.
Thank you, Karthik, and thank you, LexTalk World, for organizing this.
Thank you.
As you rightly pointed out, that generative AI is no longer a futuristic concept for all of us. It is actively embedded in R&D portfolio, design creations, and whether in-house counsels, private practitioners, you already seeing that the generational shift is happening in the whole world of AI. And this session actually sits in the intersection of technology, law, and corporate strategies. And we cannot have a better panel than this one, where we have from corporate strategies, from patent prosecution, research and development, IP strategies around it, and obviously global practice. So for the benefit of the audience, we have divided this section in different sections, and we'll try and cover the most crucial topic, obviously, is the ownership around inventorship, then corporate IP strategies, trade secrets, and then international landscape. So let me just open the session with our first section, which is innovation and human contribution debate. And as you all know, the central question revolves around whether AI can be an inventor and own the invention. And who will be better than Mr. Krishna to just throw some lights on the diverse litigation going across the globe, say, for example, US, UK, and what precautions do you actually take while responding to office objections? Over to you, Krishna.
Thanks, Saurabh, and thanks everyone for joining this session. So, as you rightly said, Saurabh, AI is here to stay. So, generative artificial intelligence, or you may say artificial intelligence, is going to stay here. There are some corporate shifts that you need to also look into while addressing this. Prosecution, of course, is one angle. There are a few other aspects. Before I go to the Davos aspect, I would also talk from the shift that you need to look from an organization point of view when you have this AI integrated with a human-centric approach. Now, you all know that a patent grant has 20 years lifetime. Okay. Now, with all the changing emerging technologies, do you think that 20 years is relevant for any technology? No. So, from an organizational point of view, you should think that, okay, what is the shelf life of my patent? Is it 5 years, 6 years? And if I have to retain for 20 years, do I still make any revenue out of it or not? So these are from an organizational point of view to think what I get post patent grant. Now, coming back to your question on the issue with respect to Davos case, etc., and I think that is something good that Dr. Thaler has come up with that kind of an experimentation, so that everyone knows, okay, what could be the future of AI inventions. Now, it is very clearly established unanimously across jurisdictions, be it Australia, US, China, Japan, and you may say all countries, that AI cannot be treated as an inventor. It is an inventor can be a human. A natural person can only be an inventor. That is very well established. So now there may be few countries like Germany and Switzerland. They have a different approach to it, probably in this Davos case itself, where they have taken a different conditional acceptance stand, where they said that, okay, now AI will treat it as a tool. You keep yourself as inventor, which is Dr. Thaler, who has actually come up with this Davos tool. So he became the inventor and used Davos as a tool. So that is as a conditional acceptance in Germany and Switzerland, you got a grant for that. South Africa is another exception where you have got a grant because there is no prosecution. I think most of you are aware that there is no prosecution in South Africa. So it is just you file an application, you get a grant. So except for this one or two exceptions, most of the countries have completely denied, saying that we cannot give AI as an inventor. And most recently, I think last week, if you have read the news also, IPO has clearly now, it was somewhere lingering that what to be done or not. On April 14th or something, IPO has also clearly stated that this Davos cases cannot be treated as an inventor. So all in all, as on date, which is seriously, I mean, a concern for many of to see what next, how you can then ensure that AI as a tool could be part of the inventor community. So there's some questions that needs to be answered by the patent offices. Of course, there are some discussions being going around to see how that AI also can be part of inventing community, I would say. So this is on the Davos part. Now your next question on how you overcome, how you navigate, or how you overcome the objections with respect to. So see, frankly speaking, we should not do a postmortem job. Postmortem job meaning you file an application and then once it comes into prosecution, there is no. You cannot get away with any kind of rejection, any kind of answering or you cannot. So the best way to deal with this is you please look at your application. So what you have to do at from an IDF stage, meaning invention disclosure, where you go to the inventors. The SOPs needs to be there. You need to have some standard operating procedures to the inventing community to ensure that where the data is coming from, who is the ownership of the data, from where, which sources it has come, and to keep it ready. And when you come up with your drafting of the application, you need to have a standard operating procedures for your drafting team as well. Where is the experimental data that is coming from? Do you need to use it in your application? Because once you get into this data mode, put all these data models, etc., in your patent application, and when there is an objection raised during prosecution, it is very difficult to, satisfy the examiner, to convince the examiner. Okay, so this SOP is to make the inventor community, understand that yes, you are coming up with training models of data, etc., but ensure that these are only from an assisted point of view, and these should not be part of your invention, because it is very much ensured that, any one of the claim of your patent application has any inclination towards AI doing this activity, that claim is anyways ruled out, but it will cause a lot of questions to the examiner, saying that, oh, this looks to be an inventor. So to avoid that, better you have these practices meaning standard operating procedures across for inventing community and your drafting community. And if you still need to have that experimental data to support because you need to have support, so keep it aside. You need to have experimental data in your specification. One of the embodiment you just put as experimental data, this has come from, so that you are navigating whatever the possible potential objection rejections that may come from the and you are actually answering while filing your drafting the application, not after you receive the office action.
Thank you, Mr. Krishna, and I really like the analysis of not doing a postmortem after doing it and be ready from the front. So it looks like it's almost settled globally that ownership around AI owning a particular or AI acting as an inventor has settled. But there's another angle aspect to it, because during the whole inventive process, AI can be an assistive tool as well. And I think who will be better than Dr. Akshay to throw some lights, because in research industries like pharmaceuticals, fluorochemicals, and other specially materials, AI discovery platforms actually create a lot of assistance while creating or finalizing any particular new molecules or compounds. So, Dr. Akshay, my question to you, like, when an AI system identifies a new molecule or a scalable process, how does a team in your organization uses AI as a discovery tool? And can you also throw some lights on the legalities around it?
I think it's a quite nice question, basically. And in most of the pharmaceuticals, agrochemicals, specialty chemicals, fluorochemicals, fluorospecialty, the R&D environment is actually driven with the data, the databases, the search databases, the search sites, basically, and the paid databases which are there. So when a new chemical entity or a new process is to be developed in the R&D or by the organization, So first, the scientist performs search basically, as you rightly mentioned that AIs are used as tools basically. So all data sets and databases are being explored for that particular chemical entity for based on the various features which are required. And once the search is completed on the databases, the outcomes are evaluated by the scientists. And it's not like something as autonomous bootstrapping that you got something in your hand and now you can go ahead directly. Scientist intervention is must actually. Once the data is come up, the entire data is evaluated and it is to be reduced into the practice for making the invention to a workable invention. So what happens is scientists in my R&D, in other pharma R&Ds, in other, I've been through many companies, so I realized that experience says that the entire data is evaluated, made a crisp report to understand that what things are to be taken up for the further development. And once the R&D trials are started based on the plans, which are based on the data available from the search sites, the experimentation is done in person, and then after experimentation, the optimization will happen. Optimization later on, there is upscaling of the process or the product, and then it will go to the commercial use. So what happens in the entire process? There is a human interventions everywhere. So that human intervention is must because the validation of the data is quite necessary. And as long as the other part comes, the legality. So, a database cannot be made accountable or responsible for an infringement issue because of, whatever has happened when you have developed a product. You realize later on that there is an infringement issue because it's a doctrine of infringement. It's actually very close to the existing prior art because the data is, probably coming up from the databases based on the existing data actually. So while developing, the scientists' ingenuity involved as an innovative aspect that what difference you have made with respect to the existing processes or the product basically. So the human involvement makes the process to be developed, then optimized, then upscaled, and this entire data, the person who is executing the entire function is responsible. It's not that data set or AI based search can be made accountable. So legality comes to the human basically who takes the ownership of this development and understand that my process is a non-infringing process, my product is a non-infringing product, so I am safe while developing a product and the process. So overall, if you see that in most of the pharma and these companies, AI serves as a meticulous tool. It saves a lot of time. It saves a lot of money as well sometimes, and you can make your execution plan so fast that you can have your products as early as possible in comparison to the past. Basically, the search was taking more than 6 months or a year's time basically when you were doing a manual search, and now you can do the search in just 1 day or 2 days or maybe 5 days or maximum within a month, and you can get the R&D processes to be optimized like anything. So the legality is actually switched over to the not to the AI basically. The entire legality will be based on the inventors and the people, the IP team which is involved to understand, to evaluate the IP issues on that. And if there is some novelty or new features, you have the lot of patentability scope on in that in filing all that. So that's what is my take on that.
Thank you, Dr. Akshay. And that brings to a very interesting point that assessment and documentation of human contribution makes a lot of sense while dealing with such AI discovery platforms. So yeah, that's kind of my takeaway from both Mr. Krishna and Dr. Akshay, that although it's well settled that AI cannot be invented, but if you are using during your discovery process, you have to document and assess the contributions, human contributions accordingly. And just to close this topic, I would like to ask Sergey, like, what are your thoughts, Sergey, around on various other jurisdictions, which, for example, like Eurasia and Kazakhstan, which have slightly different outcomes, and what are the new laws emerging in those parts of the world as well? Anything from you on this, Sergey?
Yeah, thank you, Saurabh. I don't think I will tell like something new in terms of global regulation on AI, but Eurasian system is following the global standards. And for example, in Kazakhstan, recently in 2025, they produced a new law regulating AI system in the country. This law has come into effect on January 18, 2026, just recently, a few months. And this law basically governs AI technologies, the main principles which protect the priority of the right of the person to choose the technology, the transparency, the algorithm, and of course the security behind this system. The Kazakhstan law also implements the obligatory marking of goods or services which are produced with the help of AI. Also, if there is certain goods or product, for example, which is not marked, the law sets a certain liability, like administrative fines, for not complying with the marking. There are certain, of course, regulations in terms of overlapping with data protection when AI software or product is using certain personal data like phone number, email, name of the person, and other additional information without the consent of the person. This will be under prohibition. So the consent of the person must first of all received. And other regulations which I think made Kazakhstan jurisdiction in Eurasia the first to implement AI law in all CIS countries. In terms of Russia, Ministry of Digital Development, they offered a law which, after discussion, should enter into force in September 2027, so in a year, and also provides different regulations starting from the principles of regulations of AI, the rights of persons, which must be always protected. The person can choose the technology, has the freedom to use it, etc. Of course, the obligations of the developer and the operator of AI system. And what is interesting, provides certain rules on intellectual property. So, for example, the intellectual property assets which are created by AI must meet the general laws, the civil code of Russia, and the exclusive rights to such assets arise according to civil law and shall belong to person which is defined by the agreement, for example, between the user and the developer. So at that, the law reminds that only creative results or product of intellectual activity are protected, which means that, for example, in terms of copyrights, let's say, the creative input must be shown. It's not the machine or software that is the subject that creates, but the person with the help of the software that has such rights. This is very important. Also, when users they conclude agreements with developers, they must define the process of transfer of intellectual property rights, or agree on the use of the software itself, because if you use AI to create a new solution or a new product, then the license must be received, for example. And this criteria on creativity, originality, the transfer of rights must be met. I think that there will be a discussion around different language parts on which the law is prepared, because it is obvious the first draft, and we will see more developments and activity in this particular part. But what should be mentioned in that Russia probably will be the second Eurasian country to implement AI in general, and will touch on certain aspects like intellectual property, data protection, the very other important and developed areas for the businesses, for the governments to control, for the businesses to use, and to be very careful when these segments or areas overlap. Right now it's theory, but in practice, these jurisdictions already started being IT jurisdictions by history, using different AI systems, including Gemini, ChatGPT, DeepSeek, and other these global AI platforms. But again, the law firms like our firm warn the business to keep an eye on confidentiality, because certain sensitive parts like clients' agreements, like clients' names, of course, must be deleted if a firm like our firm, for example, use this. Otherwise, all these materials become public. You educate the platform, and all these principles, clauses, language, etc., will be open to public, which is not what the client wants.
Yeah.
Thank you.
Okay, understood. So primarily net, like my takeaway from these three sections, like AI and IPR are actually going hand in hand and across all the major jurisdictions across the globe. And let us just shift gears and move to corporate strategies. And let me just ask Deepa, like as general counsel, you see legal operations across a workforce enterprise solution. And when an employee or contractor use generative AI tools like for any models or to create deliverables, how you tackle employee assignment agreements, or sort of how you have acceptable use policies in place when any employee is using an AI to create a deliverable to your end customers. So Deepa, what's your take on this?
Thanks, Saurabh. Good evening, everyone. It's been the flow is really interesting. Though the question really interests, it's really an difficult and practically a challenging aspect every general counsel has to handle this today. It's very strategic role the GC has to play in this. This one aspects where we are talking about an IP. There is an unsaid or unreturned multidisciplinary angle to it is data protection as well as your employment related laws and regulations, right? If you look at it, the balance in a system today, AI using AI adoption become one of the mandatory KRA in every function and every individual. This has been driven from a leadership to the top to bottom approach has been implemented. Whether the function can do, no question, whether it can be marketing, whether it can be technology or strategy, I think they have to show however they can adopt the AI. So if you see that out, it's a very delicate balance for a GC they have to maintain is the business push to adopt an AI, and other side is on the governance which comes to take care of, especially on your IP and data protection, which is primarily interrelated with this particular subject. Earlier, the old IP framework, as Krishna and Dr. was indicating, human invents or completely something new he develops, he will be the owner, he will do assignment. I think that's what from the broader framework we used to create it. Let me put that out your question to clarify in two parts. One with the employees, other one is with our partners, how they are contractors or service providers or partners. Employee, it's very simple in our employment contracts where you will have an IP assignment clause, confidentiality, very clear, work made for hire as a explicit keyword where we have used so that default whatever they have done, we are accountable. As you indicated, when I would like to position myself to client, It is called legally and vicarious liability. Whatever my employee does, I am accountable. Today, can I continue to maintain? That is one of the high risk where we are going to take it. The GC has to really think about it. What employee does, will the employer accountable to the client? So I think that's where we try to bring in both from our agreements with an employee, employment contracts, or you wanted to go with an separate IP assignment contract for an high value or high stake business roles or a strategy or a technology developer roles. And as well as with our clients as well, we are trying to make this out as and very clearly. This is today, it's not the ownership as an output. We are going to bring that out as the ownership of an process. Who developed is no more a question, work made for hire will get addressed. It is how and who has given the direction for the process. As Krishna indicated, the creating an SOP and process guidelines in the framework plays a crucial role than just identifying an human as an inventor as well today. One report I just would like to bring in here for all of our reference is that 2025 Gartner and Deloitte has published a report on this. They have indicated 60 to 70% of the enterprises, the resources are using shadow AI tool, which means they're all using an unlicensed AI tool or open source tool to come up with their outputs. So, how much ever the organization trying to build the control with access today, I think the shadow AI tool cannot be avoided. So, from a legal side, what we try to bring in the licensing agreement or an employment assignment agreement is very clearly whatever you develop with the support of an AI application, which is not licensed by the company, is not considered as you are the owner of the output. Firstly, you need to take an approval from us wherever you are, working on the AI license rule. Very restricted your policies, where we'll bring it out as an acceptable use policy, where he has to read, which will interlink to your IP assignment agreement, where will permit what he should be allowed to use, what is not allowed to use. For example, like a listed company, me, you are not supposed to use an unpublished financial data for any reason. It can be 5 minutes, you will get the entire data analytics with a free of cost, but you are not allowed to do that out. Similarly, your PII data, which you are not allowed, not even in any personal information carrying data, you are not supposed to use it, and even in the licensed and permitted. So, which means wherever you have done without our authorization, we call it out very clearly. You are not the owner. We are not ready to take an IP assignment. Secondly, we also tell that out, you will be personally liable for that. This is the message which we will capture in my client agreement as well. If there is an anywhere which in the system you try to bypass, you consider that as an IP developed by the particular company X or Y on behalf of employee. This is nowhere we are accountable, and we try to bring it out as part of our representation as well. A disclosure warranty representation. How we used to have a warranty disclaimer in the
Yes, yes.
technology contract. Today, explicitly we are calling it out as an AI disclosure warranties very clearly, which comes out in this angle. Uh,
Mhm.
so I think this is somewhere we can test it out very clearly on three thumb rule. If you are the owner, you want to become a owner, one, you're prompting. I think prompting is playing a key role by the human intervention.
Mhm.
When Karthik Krishna was indicating also, I was just looking at the US, when wherever the case laws which has come in, where they have indicated if there is a human intervention is not there, the machine has done the intervention of more than 70%. I think it is not even considered eligible for patentability. I think that
Mhm.
was the coming out. Even our guidelines, which was notified by India in 2025, also very clearly coming out with the
Correct.
percentage of attributions. So that's
Yes.
one. Second, the tool. What is a tool? What kind of a tool you have done? Is it a license? So the data is within your ecosystem. Then the third angle is the data. Is it, are you going to exercise some of the public data to derive your based on your LLM, or you have your own built LLM which could give you a result? I think these three aspects to be tested, completely drawn in the ambit of our
Mhm.
SOPs and the process to create awareness within the system. as well as to your vendors or contractors. Question them out. What is the AI warranty? What is that indemnity? Earlier, you just simply say that out.
Correct.
Any third party infringement, we are very clearly bringing it out as well. Anything which is created outside the permitted licensed software or without my permission on the application, and the percentage of, how much is the tools which derive the output. I think these are all the sum of the factors we are very mindful when we are working out the drafting some of the documentation with respect to this ambit.
Understood. And thank you for this Gartner report is actually eye-opening for me as well. So let me just quickly change from an employee and vendor perspective. And Sushma, my next question is from a code development engagements. And I'm sure there will be no better person than you to understand this, because code development is a multi-layered facets involved here, where we have client data, enterprise methodologies, third-party AI platform, AI-generated outputs. Can you just explain where the industry is moving in contractually allocating these IP rights, and especially in an AI augmented environment like this?
Sure. If I can start with a very simple story, right? Like I totally echo with what Deepa was saying. In the pre-AI world, IP was relatively a straightforward concept, right? So if a company built something, it owned it. And contracts were more about defining that ownership and maybe to a certain extent of licensing it. Now, what happened? AI kind of changed the rules, right? So today, imagine a typical a co-development scenario where you have the client who's bringing in the proprietary data, and you have the service provider who kind of brings in uh, the tools and the methodologies, and then you have a third party AI platform underneath, and then the system kind of generates entirely new outputs. Now the question becomes, who owns what? Right? Because you have the client who's bringing in the proprietary data for you, and more importantly, who can use what. That's where the tension really sits, because you cannot actually have a single party fully controlling the value chain anymore, right? So we've seen this play out globally, for example, in your ecosystems like Microsoft working with OpenAI, right? Where the model, the platform, and the customer data, all of these are kind of governed separately. So if you kind of try to apply a traditional one owner approach, it kind of simply breaks down. So what's emerging instead is a much more nuanced model. What probably I would like to call it as a layered rights, architecture, right? So because you have each layer to it, you have a data layer, you have a model layer, you have a platform layer, and then lastly you have the output layer. Now all of these are kind of treated very, very differently. Clients kind of mostly retain control over their data and typically the outputs which is being generated from this, right? And then service provider probably will try to retain uh, their tools and methodologies, which is, I mean, basically the underlying tools and methodologies. And then your third party platforms would kind of impose their own licensing boundaries. So the conversation, what I'm trying to say is, the conversation is no longer about just about ownership, right? It's about orchestrating rights, it's about orchestrating the usage, and it's about how do you kind of risk across that entire stack. So globally what we are seeing is a fundamental shift. AI, I would say, has turned IP from a single ownership question into a layered system of rights across your data models and platforms, and of course outputs. So, and in that environment, where is the real focus? Real focus is not or no longer just on the ownership, right? But how have you kind of structured, shared, and controlled all of this across multiple parties? So to your question on AI enabled co-development, my point is this, that IP ownership is no longer binary. It is kind of
Correct.
layered, it is interdependent, and it is very dynamic. So the emerging industry practice right now is to move away from a single ownership model towards a stack based allocation of rights, where each layer of contribution is treated distinctly, and ownership is attributed accordingly. Now if you look at, like, I would like to take up Microsoft OpenAI example only. What is striking there is that IP isn't actually jointly owned, right? We all agree it's kind of carefully layered. You have, because because of the multi-party setup there, right?
Yeah.
So at a high level, if you are looking at, if you're looking or if you're visualizing this, I would say probably you have, 4 buckets. You have a client IP, you have an enterprise IP of, the pre-existing tools and accelerators and methodologies of the service provider. Then you have the AI platforms and models, and then you have the, the generated output. So IP is completely, I mean, the client IP or the data which is being provided by the client, that is completely owned by the client with, of course, some amount of tight control over the usage. And probably they grant suppliers some limited licenses, especially given the regulatory sensitivities around the data in each region, right?
Yeah.
And then for service provider, basically what's evolving is the right to use framework,
Yeah.
where kind of uh, clients kind of get broad usage rights, but actually not ownership, right? So particularly to protect the reusability aspect across, any kind of engagement. And
Yeah.
then when you think about AI platforms and models, you have, governance which is strictly upstream licensing. So you cannot now say contracts will explicitly flow down restrictions. It includes limitations and everything. So there's
Yeah.
something called as upstream licensing also going on.
Yeah.
Now, where exactly is innovation happening? What is the trend? How do you, where is the focus shifting on is actually on the most complex layer, I would say, which is the AI generated output, right?
Correct.
You have the client ownership of outputs, which is generated using their data. You're using client data to generate some output, but of course, you have these carve-outs for, these underlying models and tools.
Yeah.
And then there's increasing use of, joint IP, or probably I would say cross licensing models in your co-innovation scenario. So
Understood.
three shifts, I can think of only 3 shifts. Probably you have more to add on, but right now as we speak, I can think of 3 shifts which kind of stand out from ownership to kind of rights orchestration. Contracts are less about, like, that's why I said I agree with what my friend was saying, right? Contracts are less about who owns what. It's now more about who can use what, how much can they use, and for how long they use. That is where we focus on contracts, especially when it comes to IP. And then
Yeah.
and then you have what is called as the granular licensing framework, right? So we are seeing a lot of field of use restrictions. You're seeing ring fencing of training data. There's a lot of explicit prohibitions on the model retraining your client sensitivity inputs and all of those. And then probably lastly, I would say the risk aligned allocation, of course, because you now have IP tied closely to liability, indemnity. I mean, it is not now, it was the case before as well, but especially around data provenance and AI hallucinations, the IP is kind of closely tied to your liability, indemnity, and regulatory exposure. So,
Correct.
so the shift to the trend, I would say the market is moving from the static IP classes to dynamic layered
IPF.
architecture, because in AI value doesn't kind of stick in one place, right? It keeps flowing across the stack.
It's pretty fluid. Yeah, so that's a great segue. Like in my practice, being an IP litigator, we call this how much you are infected. So
Exactly.
in our company, we always use a term. Okay, you are entering this. Just measure the infection level, and then you craft the agreement accordingly. So
Exactly.
considering for coming from
I just want to say that AI value is created across layers, but the overall risk is concentrated in the data. So that's why
absolutely.
probably the modern contracts are shifting from IP ownership to, the data governance and controlled usage rights.
Yeah. Thanks, Sushma. Those are some great insights. And as I mentioned, like we being in the tech sector, we use this term infection because we always have 7, 8 license coming along in picture when we are entering into any kind of contractual framework across the globe. So I'll just shift gears, and there are a couple of rapid fire questions, and these are more of a practical application. So I'll be back to you, Krishna. I believe that AI creates a lot of prior art because the kind of proposals these are giving, and this is not good for any prospective patenting opportunities. What are your thoughts where AI is throwing in some possibilities and it becomes a prior art for a patent?
So since you have asked me a rapid question, I would give a very
Yes.
rapid answer
Yeah.
that no.
Mhm.
Very confident no, that
Mhm.
examiner cannot throw me a prior art
Mhm.
with whatever AI has generated. AI can generate thousands of documents.
Correct.
Okay, so in that case, anything can become a prior art. So how do you assess obviousness, like
Mhm.
section 103 or article 56 in APX? How do you assess? Assessment is posita,
Mhm.
person skilled in the art.
Correct.
So, in any context, if you look at whatever the AI has generated, it is very difficult. And now the onus is on the examiner to say that why he has suggested me a prior art, and he
Correct.
will be liable for me. See, day in and day out, we speak to the European examiner through oral hearings,
Mhm.
attending oral hearings. We
Mhm.
speak to the examiner interviewers at USPTO. We go to the controllers at Indian Patent Office. See,
Mhm.
mostly this is not, I mean, they also understand that throwing something as what has been aged as a prior art is definitely you can easily. I mean, that is I wish that I would get, because unfortunately we did not get those kind of a prior art rejections. We are getting only those all
Traditional prior arts. Yeah.
traditional prior arts that we are
Yeah.
getting.
Yeah.
So because that is an easy way for me to say that, boss, you prove me that where is the person skilled in that who can understand what the AI has generated. So most likely I would, and very crisply I would say that I don't think we will see any kind of a challenges of those kind of prior arts coming in the near
Mhm.
future. Is
Mhm.
what, and at least we have not seen those, and I would
Mhm.
say that we can easily obviate from those.
Okay, understood. Thanks, Krishna. Those are like, yeah, because we have faced one, and that's why this question. So I'll just quickly come to Dr. Akshay on another practical aspects. Like Dr. Akshay, as you know, that we have in patent specification, your specification required to be enabled and has to be sufficiently described. So in this whole inventive process, if involves training data, model architecture, and hyperparameters, how do you approach the sufficiency of disclosure requirement? Like, what are the four corners you will not write in the specification, or you will kind of restrain yourself from writing in the specification?
So I think uh, compared from the AI or the IT industry, I can say that in case of pharmaceuticals, fluoro, specialty or agrochemicals and new chemical entities, the patenting process looks little different because though the requirements are same, novelty, inventive step, and utility, but the patenting process requires that once you have done your database search and you got your outputs, you have developed the process in R&D, and you have done the experimentation. So it's a large experimentation. You get a lot of data generated,
Mhm.
and then you evaluate the data, and then you show that when you say validation is done, it means that 3 4 consistent trials and experiments are done, and now it's proven that the process or the product is optimized, and it can be taken up for the patent filing. And that data which is for the optimize is being given for the evaluation of patentability as well as for the patents specification drafting.
Mhm.
So that data of experiment is performed by a scientist, and that data is to be converted into a working example, which is already they have performed,
Mhm.
and that enabling disclosure should be in the best mode of working of that invention, basically, so that when you claim something in the legal scope of the invention,
Mhm.
your examples which are there, your detailed description should enable the claim, your working example should enable the claim. So, not much data sets and other things may be required in these kind of patenting process, because most of the data comes from the scientists when they have worked out and when they have reproduced something and when they have produced the output on that.
Mhm.
And sufficiency of disclosure all depends on the patent who drafts, basically, but it's
Mhm.
actually a requirement where you have to sufficiently disclose the invention for a person ordinary skilled in the art.
Right.
I think he said that person having skilled in the art. I would say that even the ordinary person should be capable to reproduce the best mode example which is
Correct.
disclosed in the the patent specification. So the important part is that once the scientist data is given, it is converted into the working example, it is given in the, it suffices mostly the purpose of written description and the disclosure of the relevant part in the best mode of example.
Understood. Yeah, thank you. Those are some great insight, Dr. Akshay. And Sergey, like, what are your views? How AI is affecting patenting in general, based upon your experience?
Saurabh, so the main question, as I understand this, is whether the use of AI must be disclosed in the inventive process. So, for example, in Russia, in a jurisdiction where we mainly practice, RU-PTO, the patent office will never ask to disclose the inventive process, because this is more like a confidential thing, or which regulations do not require the applicant to disclose. However, these AI things and aspects may be disclosed in the section on substance of invention, because it is more or less relate to industrial applicability of invention. Everyone knows that there are three things that patent office will check: the novelty of invention, the inventive step, or US call it non-obviousness, and the industrial applicability, or the field of use, or other words are used. So in Russia, for example, the RU-PTO may ask that or may assert that you do not disclose the substance of invention, because, for example, you are not describing how the invention is used in this particular sphere, with the use of AI or without the use of AI. So that's why we recommend our clients, basically Asian clients, which more often file applications through us in TMT sector or IT sector, that the description of invention, which be later published even on the website or in the registrar, will say that this particular solution can be used with the use of AI, for example. So this is how we usually practice.
Understood. Those are some great insights. And just quickly changing the topic a little bit, and I'm coming back again to your Deepa. Like, given the uncertainties around AI patenting and given the complexities around it, and as we have heard from all the respective panelists here, are you seeing a strategic pivot where organizations are actually shifting toward trade secret protection, particularly for AI models and training data sets and algorithmic, as opposed to patents?
Sort of very interesting. The outright answer, definitely, at least personally, I feel yes, that clear pivot is happening. Okay, because though it's not clear on every aspects, but broadly as a strategy from a leadership as well as from a technology and legal governance, we are very clear what can be patented, what cannot be. If you ask me, Deepa, can you just tell me in a one-liner for a non-legal person to understand the patentability, to explain the techie person and tech knowledge? We just first ask the question, what is patentability? The patentability, the fundamental aspects which relies on the position of patentability is, it is a risk of replication. We would like to prevent it. That is where we try to go for patenting, to commercialize. But today I keep asking them, can your output can be reverse engineered by your competitor or any of your own peer group?
Correct.
You are not able to tell the answer outrightly, right? Yes.
Yes.
They will say randomly, maybe. I said, maybe not, maybe will not help me, right?
Correct.
You have to be very precise, and precision is required when you are doing a reverse engineering in a traditional way. You know precisely what is your source code. That's the threat to us in a technology world. So I'll tell them very clearly, if you're a reverse engineer, they may not able to identify your prompting and your data, then I don't think so. You need to really worry, which cannot be entitled for patentability. The second aspect, because why? GenAI is a black box, though we try to drive with the principle product design, product by design, move to and contract by design. As Sushma told, I just would like to, just extend this Sushma's view to this response so that it's more or completely correlated, or she
Correct.
set the context for this flow and the sequence. Absolutely, it is a layered one. So earlier patentability is an holistic approach we take. Today, I cannot go as a bundle because I
Correct.
cannot position the transparency and enablement in every aspect of the layering one.
Correct.
So we make it very clear. If you may not able to disclose the process of how, why, where, what we have done in your entire system of your layered approach, you should consider it as a trade secret. Assume that out. You are training the data models, or you trying to fine tune your way of your architecture within your own system, which, as I said, the tool which is vary for an every permutation and combination to give for your own clients. I think those aspects would be covered under your NDA, which whomever be involved with an employee or with your partner or with your client, we try to work it out.
Yeah.
The pure architecture and the model which is helping you to come out within the output of your guaranteed output, I think there we can position ourselves as in patentability. We can definitely consider for that. That's my 2 cents of thoughts on this.
Yeah, those are some great insights. I'll just ask Sushma, and she has already probably covered about the multi-layered approach. But there's one more piece which I believe, and Sushma, you might be the right person to answer this. How the organizations are navigating the intersection of various laws as compared to contracts, disclaimers, and limitation of warranty. How about the intersection of data rights, data privacy, regulation, IP protection are being governed? How organizations are looking into a AI-driven innovation aspect?
Wonderful, great question. Now, again, I would like to reframe this with a very, quick scenario, and I'll make it very short. So, because this is exactly what many organizations are dealing with today, right? So, imagine you have a company which is embarking on an AI initiative. It has kind of years of valuable enterprise data. You have customer interactions, operational insights, whatnot, proprietary data sets, and then you have this company partnering with a service provider who brings in, as I said previously, advanced models and tools, and then there's a third party platform underneath as well. At first, it kind of looks very straightforward innovation story, right? But very quickly, a more complex question kind of emerges. Can that data be used to train the model?
Correct.
Can it be reused? And who benefits from what learning? Right? So that's exactly where the real tension lies, because data today is not just an input, right? It is, I would say, it's a strategic asset. So on one hand, organizations would want to unlock its full value, improving models, driving insights, and accelerating innovation. On the other hand, I would say they're also constrained by your, first and foremost, the data privacy obligations, and then the regulatory expectations across jurisdictions.
Correct.
And then the risk that once the data is used for training, it kind of becomes very difficult to ring fence or take back. So we've seen this tension play out globally, especially being an Accenture, even in disputes like which involve the New York Times and the OpenAI, where the question isn't just about outputs, but the question is whether the underlying data was legitimately used in the first place.
Correct.
So what organizations are doing now is kind of moving towards much more controlled and intentional frameworks. They are kind of tightening the data rights, making training, you will make sure that the reuse rights are explicit rather than implied. That was the case before, right? And secondly, they are adopting towards more segmented data strategies, right? For example, if you're allowing a model improvement only on an anonymized or a synthetic data sets, what happens? Thirdly, contracts, I would say, are evolving to include clear purpose limitations, restrictions on model retraining and reuse, and as I said, increasing focus on data lineage and auditability. But to your question on contracts keeping pace, I would say partially. The reality is that technology is kind of evolving very faster than legal frameworks, right? So I would say we are not proactive, we are reactive, especially in the legal industry. So many organizations are shifting from static templates to more modular or use case specific contracting approaches, and your use case keeps changing. So you cannot say that, okay, I have these use cases and this is going to be there forever and I have a standardized template, which is not the case. So in AI, because in AI, the controlling the data is often more critical than owning the model, and that's where the real legal and the commercial battle is now playing out, right? So in many ways, data has become the new IP, and unlike traditional IP, it comes with regulatory obligations that you can't, contract your way out of, basically.
Yeah, absolutely. And thanks, Sushma, for those great insights. And this brings, yep, Deepa, you wanted.
Thanks, Sushma. So just to add on one line to and Sushma's views. Today, I know that out absolutely we all agree very outrightly that the face of the technology versus the law, right? It's absolutely unmatchable. But where I completely feel and looking at the laws, evolving laws, which is like an EU AI Act or your own India 2025, the governing principles which recently published by the government on AI, we see that what we are trying to drive more towards your risk based approach or a principle based approach rather than bringing it out. I know that out technology is very dynamic and evolving. Down the line in 3 years, I'm not sure what we are going to debate, whether it's an AI will be there or some other new technology would be there or quantum. So in that way, I look at it now, the risk-based approach is going to be very clearly driving from a legal perspective to address an areas of how and these can be handled or mitigated. High risk, definitely, the various metrics and the systems and controls and principles are very, very tightened one. And then it comes a medium and low. That's something I would like to share it from the legal perspective.
Yeah, thank you, Deepa. And that's actually brings to a closure to a session where we started with ownership, then we shifted to corporate strategies, then we shifted on a practical challenges, and then closing with alternative ways to handle and alternative things which we all are looking at. And just closing this thought with EU AI Act being one of the first AI legislation across the globe, and we can actually learn from that how to operate reverse on that front, primarily because it has an extraterritorial application. So like what we at Akamai does, we kind of divide our system based upon the legislations, how it has been given. So now we are thinking backward how we can modify our systems so that it can fit in not only the EU perspective, but also the global perspective, because gradually, as you rightly mentioned, Deepa, it's going to be the norm that risk-based approach is going to stay for some more time. So yeah, that's amazing. And I really thanks to all my fellow panelists to share their insights and I had really had a wonderful session. And thanks a lot for your respective times. And Karthik, we are open for questions if any, because anyway, just we are towards the end of the session.
Let me look at it. Let me see if someone can ask some questions. I guess there's no question.
Sure.
No
problem. Okay. Thank you, Karthik, for organizing, and thank you all of you for helping.
Okay, so let me conclude this. Thank you once again to all our speakers and participants for making this session very meaningful. Before we wrap up, we are hosting another conferences in Bangalore, which is on 11th of June. And another one is in Dubai, which is on 9th and 10th September. And last is in Mumbai. It's on 10th and 11th December. So more e-meets under Council Exchange will be coming soon, and stay connected with us at lextalk.n. Thank you very much, Saurabh sir, Sushma, and other speakers. Thank you very, very much.